Welcome, everybody. I'm very excited to be here with my partner, Rosa. We are kicking off a four-part series of Who's on the Hook. And the way we came about this is that there's just so many insurance-related issues and coverage issues that come into play when we're litigating cases. As plaintiffs, as defendants, you can't hide from issues that come up with the insurance involved in the case. And I've learned that over my 30-year career that you need someone on your team like Rosa or access to someone who has knowledge and how to navigate these insurance issues. They come up in all types of areas. And we thought it would be really helpful, since what we do at the Mentor is try and share knowledge to help everybody in our field, that it would be helpful to have a series where we talked about specific types of cases and the insurance issues that come into play in those cases. So that if you're litigating a rideshare case, which we'll talk about today, if you're litigating a construction accident case, which we're going to talk about next month on November 6th, and then the two other subject areas are going to be premise liability and SUM matters. There's lots of insurance related issues that you're going to have to deal with, whether you're a plaintiff's lawyer, whether you're a defense lawyer, and you can't sit back and let the other side deal with it and just not know what's going on. Not if you want to advocate properly for your client, right? You got to roll up your sleeves, whether you're on the defense side and you're trying to transfer the loss and have somebody else pay. And a lot is going to come down to how the policies read, who's priority in coverage, who's disclaimed, is their disclaimer valid? On the plaintiff side, you need to know who do you need to talk to get your case resolved. You could think that it's one carrier because they're the ones that showed up answering through counsel for one defendant, or maybe disclosed in discovery as the carrier involved. But it may turn out that they've got somebody else that they've passed it over to, and that's who you should be dealing with. So there's lots of issues that come up, and the idea is for us to try and highlight and try and help you navigate this. And during these four parts that we're going to do, today's part one, we're going to hit you from both angles. I will talk sort of the litigation angle, what I would do if I'm litigating these cases. And as you know, I represent plaintiffs, but I'll talk about it from plaintiff and defense perspective. If you're just litigating the case, discovery, depositions, pleadings, what you need to do. Rosa's going to talk about it with regard to the insurance issues and what goes on behind the scenes that's so important for you to know about. And you don't want to just wait until a mediation to find out, oh no, it's that carrier we've got to get on the phone, right? You need to know that in advance. And you don't want to wait till you show up at trial. So there's lots of things that you can do to proactively get a handle on all of this. All right. So we're going to get into it today, talking about rideshare. But before we jump further into today's discussion, just a couple of ground rules that most of you know from our previous CLEs. First of all, we love questions. That's what we're here for. We're here to help you. And if we don't address something and you want to find out or have it answered or clarified, let us know. Drop it in the Q&A. We'll either handle the question from me and or Rosa during the program. If we don't get to your question, we promise to start from 2 o'clock to 2:30, the last half hour of this lecture. We are going to be answering all questions. You could also reach out to us. Our emails are readily available to you. If you're watching us, you see it on our screen. If you're listening on the podcast, it's in the description. Just reach out to us. We're happy to help. We can also do one-on-one complimentary Zooms. We set up 15 to 30-minute Zooms, both of us, Rosa and I. So if you're a lawyer and you have a coverage or litigation question or anything else and you want to chat with us, you can just register for a one-on-one. It's free. We set it up, and it's a great way to just talk things out. You can do that by emailing us, or we have scan codes in the CLE behind us. You can just hold up your camera to these codes next to us that say scan here and scan for more, and that'll bring you to all kinds of links. And hopefully we'll be available to help you as much as we can. So today we're going to talk about insurance issues in ride share matters. All right. Ride share, we're talking about Uber. We're talking about Lyft. For those of us who are in New York City, in the boroughs, we use Uber and Lyft a lot, and so do our clients. Even if you're outside of the boroughs, they're very actively used more than ever these days. So not surprisingly, we're all seeing much a greater increase in litigation involving Uber and Lyft ride share situations. Who's responsible? Is it Uber? Is it the driver? Whose insurance covers the accident? Is it Uber or is it the registered owner of the car? These are the types of things we're going to talk about today. So with that brief overview, I'm going to have Rosa kick it off. Rosa, you can, kick it off however you would like to talk today. I will jump in and give sort of my litigation pointers when we're talking about these issues as they come up. And you'll see Rose and I'll have a back and forth. We do this every day of the week. So now you're just tuning into what Rose and I talk about like this all the time. So Rosa, the floor is yours to kick it off.
Thank you. Thank you, Andrew. And welcome, everybody. I'm glad everybody's here, 875 of you so far. So, I want to piggyback on something Andrew said. I think one of the biggest mistakes that you can make as a plaintiff's lawyer is to sit back and think that the defendants are taking care of the insurance coverage issues, because they're not. And sometimes, they obviously they have their carriers and they get the work from the carriers and they know who the immediate insurer is. But you don't know how many times we've had situations where a case is ongoing for a year and suddenly we find out that this other carrier wasn't placed on notice. The excess carrier wasn't placed on notice. So it really is important as a plaintiff to really be on the affirmative of that, because as a plaintiff in New York, you have a right to place those carriers on notice, where, for example, if a co-defendant did it, it's not the same right. It doesn't have the same effect. So just keep that in mind, that when you have these cases, whether it's, one of these cases that's rideshare, or we're talking about construction or something else, it's important to kind of get your groundwork, figure out who your players are, who the carriers are, primary and excess, and make sure you get those insurance disclosures so that you can get on it right away and you can send your notices as you go forward in the case. So that's aside. But on the rideshare issue, so I think that there's a lot of confusion about what kind of coverage applies in these rideshare cases. And at least for me, some of the confusion stem from the fact that the application of what insurance applies is different in New York City than outside of New York City. And so that's what kind of makes it confusing. And so it's a disparate treatment of what insurance applies, okay? But one of the things that's in common with whether it's inside, out of the city or in the city, is that the insurance industry had to find a way to delineate, like, what is this car being used for at this minute? When this accident happened, what is going on in that vehicle? So what they ended up doing was they ended up coming up with a period system. So it's period 0, 1, 2, and 3, okay? So period 0 is when the app is off, right? Period 1 is when the app is on and they're waiting for a passenger to request a ride, okay? Period 2 is when they've picked up, they're on their way to pick up the passenger. Now they get the request and they're on the way to pick up that passenger. And then period 3 is when the passenger's in the car until the point that they get out of the car. All right. And that's all in the materials if I'm going too fast on the period. So that information becomes critical in determining what coverage applies, because obviously you want to know, is it a period 0? The person had nothing to do with driving for Uber at that moment, or was it a period 3 when they were in the car? Now, one of the things that we've discovered, and Andrew's going to talk a little bit about, is that it becomes increasingly important during discovery in these cases to get the information from Uber. And just to backtrack, we always name the owner, operator, and then whoever the rideshare company is, all right, in every case. It's not like the Graves Amendment where you can't include the rental car company. There's nothing like that. The rideshare companies can be added. So we always do that. So one of the things that we do when we're sending out our discovery demands is, we want those trip logs, right? So, and do you want to jump in a little bit on the discovery?
Yeah, so in the materials, and again, they're there for you to use. You don't need to look at them now if you don't want to, but we put a lot of insurance information as well as litigation practical documents that you can copy what we've done in prior cases. And one of the cases that we used throughout the materials was a client of ours, Gwendolyn Lau. And Miss Lau, a lot of the papers involved in her case are here for your help. I'd ask you not to share them. We took out her address. They're all public filings, so there's nothing wrong with it. But please, the materials are for your use, and that's why we have them here. And what happened in her case is she was from out of New York State, arrived at the airport. She was with her friend. He requested Uber to pick them up at the airport and take them to their destination. So he used the app. They both got in the car, and they were involved in an accident while driving en route. So this would have been a period 3 based on Rosa's description. And so the materials that we've included for you are the complaint, so you can see how we name everybody. And you'll see that we named the driver of the car. His name was King Guo Du, and we also named Uber Technologies. Now, what normally you'll find, certainly in the New York City 5-borough setting, it's a little bit different when you get further out, and definitely for those of you who are outside of New York, and we'll talk about how it's different. Rosa will address that. But in New York City, typically what you'll see is a taxi and livery commission vehicle. Where it's either a black car, it's a taxi, and they will use the Uber app, maybe they'll use the Lyft app, maybe they won't use any apps, but when they're acting as a TLC in New York, they're required to have certain amounts of insurance coverage. On the registration for that car is going to be the driver's name and the owner of the vehicle. So like in any other case, you're going to want to name the driver of the vehicle and the registered owner of the vehicle and the rideshare company. So in this case, Mr. Du was the registered owner as well as the operator of the vehicle, and then Uber was the app that was being used at the time. So you name them both, and then you got to get it going in discovery, and you've got to do a little bit more, actually a lot more than you would if it was just against Mr. Du, because in order to go after Uber or Lyft or a rideshare company, you need to get a lot of information and argue a case against them. And Rosa's going to talk about that. And the way that you start doing that is you request a lot of information, and you can do it in your discovery. So in the materials, we have what's called the demand for production of insurance agreements. We have demands for all kinds of stuff in there. We have the insurance agreements, expert witness information, a demand for electronic data. We have a request for production pursuant to Federal Rule 34. We brought this case in federal court in the Southern District. Many of you know I've talked a lot about the pros and cons of state court and federal, if you can do it. Our firm historically has always, when possible, based on diversity, if we have a case against a cab company, a TLC, a rideshare company, and if we have diversity of citizenship, which is a basis to get into federal court, we drag them into federal court. And the primary reason for that, there's lots of them, but the primary reason is you're going to get the discovery. You're going to get it. And they don't like to give it up. They want you to sign confidentiality agreements. They want you to, seal records. They'll fight you. And if you're in state court, they're going to object. They're going to stonewall. You're going to make a motion. Good luck. It's a lot harder to get the discovery in state court. I know that's where we usually are. So you have to be diligent. So you just convert the demand that we gave you into a notice for discovery and inspection, and you ask them to produce. We have a list in our production of documents of some 36, 49, 50 items that we demand. Trip logs, right? Reports, internal reports. You're going to want to find out everything that went on in our case between Uber and Mr. Du. What do they correspond with in this situation? Is it show that he's on duty, off duty? You can get trip logs. You can see when he had a passenger, when our trip started, when it stopped. They have GPS speed data you can get. You could get their employment contracts. You could get all kinds of great stuff. And it's really important you do it not just for was this a period 1, 2, or 3? Was it during the pickup? Was it on call? Was he on the app, off the app? You want to get all of those logs and request them. But you also want to start laying the groundwork for the fact that the rideshare company is in fact acting in the capacity as respondeat superior, that they are driving this ship, that these independent contractors are really agents and employees of Uber. That's where you're going to get the pushback. Uber is going to fight you tooth and nail. I can't tell you the depositions you'll find can be very frustrating because every time you ask a question, and how long were you an Uber driver for? Objection, he's not an Uber driver. He's a driver using an Uber app. Every time you try and say something like that, there's going to be objections, and defense counsel is doing the right thing because they have to protect their client, and they're trying to argue the whole time that Uber has nothing to do with this other than, oh, they're just an app. They're just a matchmaker. You as a plaintiff need to argue Uber does a lot more than just be a matchmaker, okay? And they're in it up to their elbows. And if it comes down to motion practice, the courts are going to have to determine whether or not their employees, whether their contracts, and all of that. And usually both sides don't want the courts to decide it. Rosa will talk about where the state of the law is with regard to independent contractor employee, but you need to show you're ready for that fight, to drag them in, to do the motion practice if needed, because that's ultimately the only way we have found that you could really get them to the table. All right, Rosa, back to you.
So just to go back to the Lau case, what's interesting about that is they claimed in the very beginning that the driver was not driving in his capacity as a livery partner. That's the phrase they like to use, okay? And we got the trip logs, and when we got the trip logs, interestingly enough, it was blank during the time of the accident. But our client clearly summoned the Uber on the app. They clearly were in an accident with the guy driving. It was reported immediately thereafter by our clients. They called Uber and reported it. They reported to the Taxi Limousine Commission. And ultimately, that didn't become an issue in the case, but it's just interesting and something to note. And I don't know if it's because we just didn't get all of the logs, but something went on there. So just, buyer beware, take a look at the logs when you get them. So now the thing is that I'm going to talk about inside of New York City and outside of New York City. And when I say New York City, again, I'm talking about the 5 boroughs, not just Manhattan, okay? So let's talk about outside of Manhattan for a minute. So outside of Manhattan, the Vehicle and Traffic Law of New York, it's Article 44, and it's like 1691 to 1700. That's the section, right? And that was added to basically take care of a situation where we're using a rideshare vehicle. And that section dictates that if there's a vehicle that's being driven as an Uber or Lyft outside of New York City, that platform has to carry a group policy, okay? And the group policy has to provide $75,000 in coverage if it's a period 1 accident, okay? So at least you're better off than the mandatory minimums in New York, which are $25.50. It's a $75,000 per person, $150 per accident. If it's a period 2 or 3, they have to carry $1 million. If you go on the Uber website, and we have included them in our materials, they give you the certificates of insurance, and it shows you, and you'll see $75,000 is for period 1, and then they provide 1.25, I think it is, for period 2 and 3. Okay, that's outside. So Long Island or wherever you are, that's what's covered. And in those circumstances, the driver is covered under the Uber policy. All right. Now let's flip to outside of New York City.
The inside
New York City. So now inside New York City, the drivers are required to comply with the minimum requirements for the Taxi and Limousine Commission. So what happens is they have to have the minimum insurance, which is $100,000. So typically you see that the driver has $100,000. You see American Transit, that's the ones that we see, that's when we see all the time. They carry property, and they're supposed to carry PIP according to the VTL. So they're supposed to carry this insurance, and then Uber, who has a lot of coverage, you bring an Uber, and Uber takes the position in every single case, and I already saw a question in the question and answer, that they don't owe coverage to the driver. Okay, it's their position that this driver is not covered by their policy. All right, so I'm gonna talk about two different things when it comes to that, and I think people get confused. So you have to look at coverage as opposed to liability. It's two completely different things, right? So is there coverage for this driver? If the driver qualifies as an insured under the policy, then they're going to be covered under that Uber policy. If they don't qualify as an insured under the Uber policy, they're not an insured, okay? That's different than, does Uber have vicarious liability, or are they liable for the doctrine of respondeat superior? That is a different question altogether. Now, whenever you commence these litigations against Uber, at least in our experience, you have to sign these confidentiality agreements. So we can't discuss with you what's in their insurance policy. So, we can't do that. And I have not had an opportunity to be in a litigation where we're challenging coverage against Uber. But I will tell you that that is something that I think everybody should look at if it becomes an issue. They claim they don't cover the driver. All right. So now they have gobs and gobs of coverage, but they say it's just for Uber. Again, as this question number one, they're saying they're not vicariously liable and they're not the employer, right? And there are cases that support that position. In fact, there's several New York Supreme Court cases, and one came down in May. I have it here someplace in the materials, from Richmond County, that said basically that the driver was not an employee, okay? I could not find an appellate division case. The question says something about Duncan. I'd like to know if someone can give me that site so I could take a look. But I did see a second department case, but they said it was a question of fact, okay? The other thing I'm going to tell you is that I know that California, New York, and Washington all have agreements concerning benefits for these drivers, and the way that it reads is they want to keep their independence, but they also want some of the benefits. This legislation doesn't necessarily say they're an employee. The one from New York doesn't, at least, but it's something to keep in mind. So, although Uber takes that position that they're not an employee, and some of the cases do support the fact that they're not an employee under the facts of that case, that doesn't mean that they're not an employee under the facts of your case. So you should take a look and look at each one of the discovery demands that we send and make sure that you ask those questions so you can develop that control.
If you're listening via podcast, the first attendance verification code is POD115. Again, that's POD115.
So if I understand you correctly, basically when you're handling these cases, there's a couple of big distinctions you need to figure out right off the bat. If it's outside of the 5 boroughs of New York City, then you're likely going to be in a situation where the coverage available for the driver and that car is actually provided by Uber for that driver. They provide the coverage. The driver doesn't have their own coverage that comes into play first or second or in any effect. If it's within the 5 boroughs of New York City, the driver of the vehicle has coverage, and then Uber has to have its own coverage. But it's only their coverage if you can prove that they're liable somehow in the happening of the accident. Whereas if it's outside of New York, you don't need to prove Uber is somehow liable because you're going to get the coverage that they afford. Am I summarizing that properly?
Yes,
Okay.
that's correct. And so just think about this for a second with respect to accidents outside of New York City. So personal insurance policies, your auto policy does not cover you if you are working as a livery driver or you're transporting passengers or goods for a fee, okay? There's an exclusion. And the VTL also permits them to exclude anybody operating as a rideshare driver. So there's a section of the VTL. So that if these people are doing that and they drive and they don't have, they're not covered by Uber, there wouldn't be any coverage. And that's why the legislature said, no, they have to have the coverage. Because the Taxi and Limousine Commission was involved with the city, it's a different story. So, just beware if you have a friend who's driving people to the airport on Saturdays and says, oh, I'm not going to go through the Uber app, I'm just going to be doing these rides. They're likely not going to have any insurance if they get into an accident. So now going back to the in-city use of the Uber car, again, they're covered by $100,000 primary policy. Now, I find it interesting that the Uber policies that are issued outside of New York City cover the drivers, but the ones in New York City don't. And I think that remains to be seen. I haven't seen any cases that talk about that yet. I've seen plenty of cases that talk about, liability, whether they're vicariously liable, whether they're really an employee. So what I would say is I think it's going to be a matter of you getting the discovery and then determining what the role is of that person, with Uber. Who knows? You just don't know when you first have a case what the relationship is with Uber. So, we have found that they have settled with us on cases. Perhaps they didn't want that appellate division decision to come down and say there's an employee relationship. And like I said, there was an appellate division case, Second Department 2020, that said it was a question of fact. So that means it's possible that they could be deemed an employee. So again, when you look at the demands, we have a bunch of different things in our demands, and some of them, are asking basically, are there incentives for the drivers? We're asking for different questions to prompt to see if we can somehow make a connection and find that control or develop that control between Uber and the driver.
And there's lots of ways, Rosa, just if I can jump in, because I was looking at some of the questions and people are saying, well, how do you get it Uber then if you're in New York City? How do you get them to the table if they're not under respondeat superior and you can't show liability? Well, that's where your craftiness as an attorney comes into play. This is an art, not a science. You have to say, what do the drivers have to do to make sure that they're allowed to use the Uber app? Do they have to certify that their car is in good working order every month or so? Do they have to have them inspected? Does Uber require that their cars be inspected before they go off? Maybe the driver says, oh, my rear tire fell off. It wasn't my fault. And Uber says, what do you want from us? But suppose you find out in discovery that Uber requires the cars to be inspected by a garage every month to confirm the tires are torqued properly, everything's working, and that if they don't, they aren't allowed to drive. And let's say in your case, you find out that they didn't do it. Or maybe there's another issue. Maybe there was complaints, and maybe they were under their own rules. They were supposed to suspend the Uber driver from using the app, but they didn't. And that bad Uber driver got back in the car and caused an accident. Then you could make the argument that, look, they had noticed that this person was a troublemaker. They had noticed that they weren't complying, and they let them use the app anyway. But for their use of the app, the injured party wouldn't have gotten in the car because that's how they got in the car. So you want to request and really dig deep, and we give you lots of ideas in the materials of things to ask for. But you'll see it's not just as simple as a driver signing up, I want to drive for Uber, and then off they go. Uber now has a lot of requirements. There's a lot of back and forth as far as forms the drivers have to fill out, as far as screening that has to be done. What if the Uber driver was a convicted felon who was not allowed to drive the car and they didn't do the background check properly? So there's lots of different ways, but what you have to do is you have to at least give it a shot. You have to make a viable argument that you could submit in opposition to a motion for summary judgment. Because if Uber makes their motion, or Lyft, to get out of the case, they move to dismiss saying, we're not respondeat superior. This wasn't an employee. We want to be out of the case. you need to have that discovery so then you could push back and say, there's an issue of fact here, Your Honor. Look, they didn't do their inspection. They knew this driver was a problem. They let him continue to use the app. But if you haven't done this and you haven't done your deposition, if you haven't done your discovery, you want to press for a deposition of someone from Uber or Lyft. That's why you want to name them in the case, if that's where you're going to get the coverage from, so that you can ask them all these questions, as well as the driver. You know, we usually get the drivers usually think they are employed by these companies. You know, you ask them, you know, when you were involved in this accident while my client was in the back seat and you were operating the Uber app, were you under the belief that you were driving as an Uber driver? Yes. As an Uber employee? Yes. And the paycheck to you is coming from Uber? Yes. So when you get those types of answers, which you probably will, that's going to help you. So you need to do that. Okay, back to you, Rosa.
So I want to post something in the chat. I found this when I was doing some research. This is a really, really great, it's a frequently asked questions page from the Department of Financial Services. And it goes through a lot of really good questions. I guess they're frequently asked questions, and there's 29 of them. And they talk about the insurance. They talk about, for example, one of the interesting questions was, if the accident occurs, if they pick up a passenger outside of the city and they drop them off in the city, what insurance applies, right? And they said, no, they don't have to comply with the TLC. They can have the other insurance. So it's just some interesting questions that they ask. And if we have extra time or something, we can go through some of them, but just take a look and take a look at that link. Now, a lot of people also ask about excess coverage. And this is what I'm talking about for the TLC drive. So this is one of the things where I find that Uber's position is inconsistent, right? They say it doesn't cover the Uber driver, but then they also say that they're excess. Well, as a coverage person, that makes no sense to me. Either you cover the driver and the policy's excess for the driver, or you don't cover the driver, and then there might be co-insurance. So it doesn't make sense to me, that statement, but they make that statement all the time. So they always insist, at least in our experience, right, Andrew, that $100,000 has to be up before they'll even put $1 on the case. And that's just what we've encountered. Another important thing to keep in mind with these, if your client is the one that solicited the ride, so they're the ones that went on their app and they solicited the ride, Uber has a mandatory arbitration provision in its policy. In Lao, she didn't solicit the ride. It was the boyfriend who solicited it, so we didn't have that problem. But I know that they do seek enforcement of that. And I cited in the materials a couple of cases. What the courts say, the First Department has enforced those arbitration agreements. And the First Department says basically it's two different things. It's called the click wrap, when you're on the app and then you have to click it and then you accept, or a scroll wrap, they call it. And you have to, scroll to the end and then you accept the terms. And that, the terms are mandatory arbitration. So like I said, I don't know if that's good or bad. Maybe it's a fast way of getting through it, but
yeah, let me share my thoughts on that. So depending on your venue options, I'm a big fan of arbitration, and I see it a lot. Some of you know I'll handle gym and personal trainer negligence cases. So a lot of the gyms will have mandatory arbitration clauses in their gym membership agreements or in training agreements. And when I see those, I had a case once where our client was injured at a gym in Westchester County, which those of you who practice personal injury law in New York know that that's not the friendliest venue for plaintiffs. And that's where the case would have had to have been brought. And then I saw in the agreement that there was a mandatory arbitration provision. I said, hey, I'd rather go do an arbitration than have to face a Westchester County jury in this case. That was our take on it. And we did the arbitration, and it went a lot faster than it would have gone in court. We moved things along. We had an arbitrator at the ready to handle any discovery issues and motions, and it ended up working out really well for us. We got an arbitration date, and we got the case resolved ultimately right before the arbitration commenced. But it may be a better option to do that because I don't know. And if any of you are defense counsel for any rideshare companies or for other companies that have mandatory arbitration, if you know ultimately you're going to be facing the possibility in these cases of Uber or Lyft making a motion to dismiss and get out of the case, you might be better off with an arbitrator handling that motion than with a judge or going outside of the arbitration proceeding, which is not easy to do. So you may want to just keep it in arbitration. You file your petition for arbitration and off you go. So something to consider and not be too worried about. Frankly, I don't think jurors are doing that much better than arbitrators as far as awards these days, and there's a certain sense of certainty to it. So something to think about as far as mandatory arbitration, but I wouldn't be worried about it. If you see it there, embrace it and go for it, and your case will probably move a lot faster.
Yeah, so then the really the other thing I want to discuss, because I get a lot of questions about this, is whether or not there's underinsured or uninsured motor vehicle coverage, right? So, you know, there used to be, and you know, years and years ago in the beginning when all this kind of started to come up, I do recall there being SUM coverage.
So can you just, for some of the attendees who may not know what SUM, underinsured, uninsured is, can you just give a brief primer on that?
Sure. Okay, so uninsured and supplementary uninsured / underinsured motorist coverage is a coverage provided. Uninsured motorist is mandatory in New York State, and you have that coverage in the event that you are in an accident with somebody that does not have insurance, or they don't have enough insurance. And so you can purchase, for example, on your own policy, you can purchase a certain amount of limits of uninsured / underinsured, because it's both. That's why I say
What we
that way.
call SUM collectively.
Right, SUM. And you can purchase a certain amount of SUM to protect yourself in the event that you're in an accident with somebody who doesn't have enough coverage, like a $25,000 policy, or has no coverage at all, which happens quite often.
And it protects you if you're in your car, if you're a pedestrian and get hit by another car that doesn't have coverage, if you're on your bicycle and get hit by another car, or it also covers all members of your household and protects them as well. Really important to have it, people.
Yeah, and it really doesn't cost that much when you purchase the coverage. It's good to have. You can only have as much SUM coverage as you have liability coverage. And the reason is they say you can only protect yourself as much as you're going to protect others, you know, so that's the reasoning. So, you know, get as much as you can. If your policy is $250, get $250. You can buy umbrella SUM. We've seen that, and that's really nice when you purchase the umbrella, because sometimes it's $1 million on top of, and it you know, it's something that is it's quite frequently invoked. I mean, a lot of times there are accidents, people just don't have insurance, or they don't have enough insurance. I mean, if you get into an accident with an Uber car, it's $75,000. So is that going to be enough? I don't know. You know, depends on your claim. But, you know, the thing is that with the uninsured, underinsured motorist coverage, we've recently gone through this and done analysis, and we didn't see it available. Generally, we have not seen that they provide the uninsured, underinsured motorist coverage. But that doesn't mean that your client doesn't have an avenue to recover that. So if your client is a passenger in this Uber car, now your client's going to look to their own coverage, okay, if they have it, or members of their household. What coverage do they have? And so on and so forth, okay? So, you know, there is other options for coverage. If your client doesn't have a car, doesn't have any insurance, and doesn't live with anybody that's got insurance, then you're out of luck. But that basically is what the situation is with uninsured, underinsured. And
generally, Rosa, it would probably be a very limited fact pattern where you would really think about pursuing the SUM coverage, even if one of these apps had it, because like if Uber had it, because if you're in the car, the likelihood is if you're injured, you're going to be bringing a lawsuit against that vehicle that you're in as a passenger, right? I guess the where it wouldn't be where the situation would apply where you may want to go after the SUM, maybe if you're in a stopped Uber and you get rear-ended by another car, right? And you just don't see any basis of liability against the driver of your car or Uber or Lyft if you're in it. And the car that rear ends the Uber that you're in or your client is in has no insurance or minimum insurance, then you would be looking for SUM coverage. So the first thing you would do is you would look for the vehicle you're in. You'd look to see if the owner and driver of that vehicle has SUM. You'd look and you'd request all the policies to see if the rideshare company has it. And you would also want to look and see if your client or any members of the household have SUM. It's malpractice if you don't do that. You have to explore all those different areas of coverage. And the last part of the series, I believe, is going to be on SUM and insurance issues. So we'll dig a little bit deeper into that. But
Yeah.
usually you're unlikely going to get SUM coverage from one of these rideshare companies, and the fact pattern will usually be such that it wouldn't be available anyway.
Yeah. So I see one of the questions that someone's asking, I thought Uber cannot be vicariously liable for an accident, whether an employee or not, due to them not owning or operating the vehicle. I have yet to find case law that states something different. So I believe, Erica, you're right, that vicarious liability, is statutory. It's VTL. I don't know if it's 313. I don't remember the number, but it's statutory, and it said an owner is vicariously liable for the acts of the operator. So in that sense, vicarious liability you're correct. They're not going to be liable because they don't own the car. And I think that's why you see the cases, like you see some cases talking about vicarious liability, and then you see the cases talking about respondeat superior, because I think people kind of switched gears and said, well, no, now we're going to prove this. It's kind of like an employer-employee relationship. So I agree with you that is, I think that vicarious liability really isn't the argument that's going to win in this particular situation. I think it's potentially proving that employer-employee relationship. And like I said, honestly, I haven't had an opportunity to do research across the country, but there's got to be gobs of cases that analyze this issue. And it's all over the country. So, I think that at the end of the day, it's going to depend on your case. I had heard from somebody that sometimes they have people that are full-time Uber employees. So I don't know if we have that in New York or not, but I have heard that exists. So you just don't know until you have your case and you examine everything that's going on.
I think from a litigation, perspective, if you're litigating one of these cases, my suggestion is that you litigate it under the assumption that there's issues of fact and that each case is going to be different. There's no federal preemption. There's no set law for these cases. It's different states, different jurisdictions, different fact patterns. So the best you can do is say, all right, we don't know, at least in the boroughs, if we can go after Uber. We don't know outside of the boroughs if we can go after them above the coverage that they've provided, but we've got a shot. And let's make as strong a record as possible that there's issues of fact in case that motion is made. Because neither side, the plaintiff or the defendants, are going to know which way the courts are going to go. And as we all know, it's that uncertainty that often fosters resolution and settlement.
Yeah, and I think there's, again, a lot of questions really referring to this, that Uber, as far as I know, hasn't taken a verdict on this in New York. I mean, we would have heard about it if they did. And to the point where I did the research to see if there was even appellate division cases on like motions for summary judgment, and I didn't see one. So it's going to take, I think, getting up to the appellate division, maybe even the Court of Appeals, to determine this question. And I think that what's happening in our experience is that Uber doesn't really want that doesn't want a bad decision either. They don't want that. And so they're trying to resolve these cases reasonably with the other side so that they don't have, bad law.
Yeah.
So, I think that at the end of the day, we're all going to keep litigating this, and we're going to find out at some point that there's going to be an appellate division decision, because one of these decisions is going to go up. The one, I don't know if they're appealing it, but the one that just came down in April from Richmond County, I mean, that might be appealed. And that'll be something to look out for.
Yeah. And I think everybody, if all these cases ultimately are decided as issues of fact, or issues specific to each case, they may say in that case, where we ruled they were an independent contractor and not an employee, that's based on the record that was in front of us, right? So that's why it's going to depend on your record, I think, on each of these cases, until there's some type of global law, either statewide or federally, that is going to address this in one full swipe. And I think everybody's a little scared of that on both sides. So that's the good news, is that's what's helping to resolve these matters.
So if you go on to Uber's newsroom, I'll try to put this in the chat too. This is where they talk about, Michelle, maybe you can help me post that, because I keep posting it to the private chat. Can you put it on the other chat? So thank you. So there's a statement from the Uber newsroom, and they're talking about that the U.S. Department of Labor and is working on worker classifications, because again, they want to provide benefits to these people, because some of these drivers, this is what they do for a living. They drive every day. And so they're trying to give them the benefits, but at the same time, all the articles keep saying is by keeping their independence, right? They want them to keep their independence. So, all right, so we only have 5 minutes. So I just want to kind of go back and summarize, because I feel like it was a lot of information to absorb. So
we got to give Michelle time to do the last set of
before
the end of the hour.
Okay, so Michelle, whenever you're ready, you let me know.
Okay, yeah, keep going. You're good.
Okay, so first we talked about the periods, right? And this is important. This is something that the insurance industry came up with, but it's used not only by the insurance industry, it's also used by Uber themselves and in liability to see what stage this driver was driving the car at. Okay, so there's the period 0, 1, 2, and 3, right? And there are sometimes I've seen policies that just cover 2 and 3. And like, for example, on Long Island, where they have the one that covers the 2 and 3, and then the policy that covers the period 1 is that $75,000 required policy. I also read somewhere, just as an aside, that drivers can get their own commercial insurance on Long Island or outside of the city. And so that is something to look out for. They might have that. In which case now there's going to be an analysis of what's primary and what's excess. I don't know the answer to that. So with respect to that, back to, in summary, outside and inside of New York is different. And I know we deal primarily with the New York City cases, but we've also had cases outside New York City that you have to look at what the different limits are. Always ask for the policy, even if it's under a confidentiality agreement, ask for it. And take a look at it. And what we did is, okay, so they have all this coverage. They didn't give us all the coverage. We didn't need to see, every single policy. That's onerous for them, and we didn't need to see that. So we said, no, just let us see, in all fairness, we'll just look at policies 1, 2, or something like that, okay? And we looked and we'd analyzed the policy. So that's something I definitely recommend. Again, with coverage, if somebody gets into a situation where now all of a sudden Uber is saying, this is a city accident, we're not going to pay $1. We're not going to pay a dime. We don't owe it. No respondeat superior. We're not in this case at all. No employee relationship. Then maybe it's worth looking at the insurance policy to determine whether or not the driver is listed or qualifies as an insured in some capacity. I don't know the answer to that, but I do know that under a normal insurance policy, that a permissive user of a vehicle is an insured, right? And so, here's the argument, like, is that a permissive user? They don't own the car, but you're allowing them to use this car for your business, right? And there are also provisions in a personal auto policy that actually provide coverage to, for example, let's just say your employer is liable because you're working and you're in the middle of doing something for your employer and you get into an accident. There's actually a provision in the personal auto policy that provides coverage to the employer. So it kind of goes both ways. It could be coverage for Uber, but that doesn't mean that their policy doesn't have coverage for the driver. And then the last point I think that we were talking about really is the mandatory arbitration, that it's been upheld, and that if you click or you scroll, you're going to agree to it, and you're going to be bound by the mandatory arbitration.
So what we'll do now that we're hitting the Q&A, a lot of the questions that were asked that I've just been looking at were answered. So we're going to try and address the ones that we don't think were necessarily answered. And thank you. I see some of you put in the Duncan site, some quotes from some decisions, and briefly looking at a decision that granted the motion for Uber. I'm seeing that the court said that the plaintiff failed to raise an issue of fact. And that's what we're talking about. And so a lot of the questions that I'm seeing are, well, if it's not respondeat superior, and they're not employers, what theory is it? And it's going to be a negligence theory. It's going to be that they were negligent. They had this app and they let this driver use it to get it, but they shouldn't have let the driver do it. And the accident shouldn't have happened, but for their negligence and allowing this alleged dangerous driver out there. Or if you can make an argument that the record establishes that in your case, they were an agent, they were an employee. So those are the two theories. It's negligence or it's agency employee. But to do that, you have to make a record. You can't just generally allege it. And I'm sure that's why the majority of these motions letting out Uber and Lyft are granted, because the plaintiffs didn't develop anything in discovery. They were just litigating it like a normal accident case. And then this motion shows up and they're like, okay. So, now that we all know this, you can't sit back. You've really got to litigate these and establish each record's going to be different. So why don't we go through, Rosa, are there any things you want to touch on?
Yeah, I just want to add something to that, because I know that Uber can suspend somebody's, I guess,
privileges,
privilege
app use. Yeah.
Right. And I know particularly in our case, it was suspended and for a period of time until they sent back pictures of the car. So there are reasons why they can do that. So, that's something worth exploring. What is the basis that you can suspend somebody's privilege to be an Uber? What is it? And you never know. It could be something to do with something that your driver did or didn't do. So that's another avenue to take a look at.
Yeah. I mean, the takeaway is dig in, do your discovery, get a deposition of the driver. When you question that driver, ask that driver all these questions about what that driver believes his or her relationship is with Uber. You'd be surprised. A lot of these drivers are going to give you a lot of great answers. They're going to say, yeah, that's how I make a living. I work for Uber. Okay. And that's going to be in your record. And how's the judge going to dismiss a case when the driver is saying, I work for Uber? Uber is going to push back and say, well, they may think that, but they don't really work for us because here's the fine print. And then you say, all right, well, this driver had to speak through a Cantonese translator, and they don't speak English, and I don't see any of your records and documents that you provide to them were translated, were in Cantonese. So what makes you think this driver had any reason to believe they weren't employed by you when you're dictating the terms? So you want to depose the driver, you want to depose someone from Uber, and then or Lyft, and you confront them with the testimony of the driver. Well, this driver says that he's employed by you. Have you made it clear that they're not employees? Show us. Where in your materials do you make it clear that they're not your employees? And that gives you the basis to get more discovery. As far as insurance, Rosa, you could probably find her lecture for the Academy on the Comprehensive Insurance Disclosure Act, CIDA. You'll see in the materials where our insurance demand is. The language is taken from CPLR 3101F, I believe, which is the state version. We were in federal court, but you're allowed to ask for any, and you should ask for, and your adversary, if you're a plaintiff, the defendant has to provide every applicable policy. They may want you to sign a confidentiality agreement before they provide it. They may want to redact it, but you keep pushing, whether you're in state or federal court, you want all policies within reason. And you want to read them all. And if you're not sure what they say, then reach out to Rosa and she'll help you look at them, because most people don't feel comfortable reading through these very detailed policies, but she knows where to zero in on it. So let's look through some of these questions. We answered a lot of them through the program. I see Matt was kind enough to say that a related area may be claims arising out of accessoride limo cases. Rosa, have you seen anything like that? Any accessoride cases?
I have not. I have not. I saw that and I was going to look it up. I'm really not even familiar with it, but I know there's so many of these things coming out. There's like, the peer-to-peer where, you rent out your car, your fancy car, and you get so much a month for it, and for people to just rent it. And I know there's so many of these things coming out that I don't know. I would have to go on and look at it. And also, look at the website, because sometimes they provide the coverage. I mean, a lot of times, like, for example, I looked up the peer-to-peer yesterday because we had a question about it. And the company provides the insurance as a group policy. So for everybody. So, that's important to know. And now, of course, you're just covered when you're using the car. So that's a whole other ball of wax. What happens when you're not using it you're not renting the car out? That's something to explore.
Yeah, a lot of these, whether it's accessoride, whether it's some other situation, you're not going to know the answer until you get involved. And unfortunately, you're going to have to file litigation and push to get these policies. And it's, if you're defending these cases, the burden's on you. You have to be diligent when you get a demand for all applicable policies under the Comprehensive Insurance Disclosure Act. You need to do your homework if you're defending an Uber driver, right? You need to find out, did Uber provide coverage? I need to get those policies. If it's accessoride, who's providing the coverage? So a lot of this is, you're not going to have quick answers as much as we like to give you whatever quick answers we can. You're not going to know some of these answers until you dig deep in and find out.
Yeah, and the defendants are supposed to, the Comprehensive Insurance Disclosure Act said that there's supposed to be an automatic disclosure within 90 days, just like in federal court, where they have to disclose it with their Rule 26. But I find that nobody does it. You have to just push and push and push. But it's something that should be pushed, because that's the basis of your recovery for your client if you're a plaintiff.
Now, I see something really interesting in the Q&A. Joanne was kind enough to post as follows, quote, in workers' compensation cases, Uber and Lyft are considered employers of the drivers. This is similar to the rules for taxi livery drivers who operate from a base. So I find that really interesting. And I would argue that if in discovery, you want to find out if the driver of the vehicle using the Uber or Lyft app, who we would call the Uber or Lyft driver, if they claimed an injury. And if they did claim an injury, did they submit it through workers' compensation? And was there a finding? Because I would certainly argue that's collateral estoppel. That, if a court already determined that they were employees such that they were given, workers' compensation benefits, then they're stuck with that. They had the opportunity, Uber, Lyft, the employer, they could come in front of the workers' comp board and say, no, they're not an employee of mine. We're not doing that. So, if you have that situation, I would probably add that to our list. I think that's a great point of discovery. Did defendant submit for workers' compensation benefits as a result of this accident? Defendant driver. And then dig into that and see what you can find out. I think that's.
I know that with workers' comp findings, usually, at least in parallel with the litigation case, it's persuasive, even if nothing else, right? So
Yeah.
Even if it's not binding, it's persuasive, and at least you can put that in your motion or your opposition or whatever it is to show that, they recovered workers' comp, or that in the workers' comp context, they're considered employees, which is interesting.
Yeah. I see a question from Mylene where she's saying that the defendant in a case she has rented a car from Avis and they got a discount through Uber driver partners, and you're looking to see if you can get Uber on the hook there. I don't see it happening. They just have no connection to it. They used a discount. It's like Google offers all of its employee discounts for codes and all of that. It doesn't mean you can have a claim against Google if someone rented the car using their code. So I just unfortunately don't see that there. You may be stuck. You should look, Mylene, look into any underinsured SUM coverage for that.
Yeah, and in the materials, I didn't go into it here, but I put a little section on rental car and loaner cars, because I think people get confused with that also. And I just put some information on that. And interestingly, in New York, even though, the Graves Amendment doesn't allow you to sue the rental car company, the rental car company does have to provide the first $25,000 in coverage and defense. So it's kind of an interesting dynamic there. So they are on the hook for something and no fault, I believe. So, that's something to look out for. Let's see. What about a ride originates in New York City but ends up in Westchester? I believe that they have to have if it originates in the city, I believe that they have to have the taxi and limousine commission minimums. And you know what? Well, if Andrew looks at the next question, I'll actually look in that frequently asked questions. I think they answer that
Yeah,
question.
they may, because I see a couple of other questions. Well, they started outside of New York, ended up is it the point of origin? I would imagine, and see if it's in the FAQ, Rosa, while I'm chatting, but I would imagine that it's going to be where it's registered, where its home base is. You have to follow those rules. So if the car is a city vehicle, even if the accident happens outside of New York City, it's going to be following the city rules. If it's a vehicle that is based outside of the city, I would imagine it would follow that. So that's probably the case, but we'll see if we can find an answer before we wrap up. Hugo is asking whether we have any insight on whether Uber and Lyft could be liable, knowing drivers are on their cell phones and causing distractions by their app notifications, alerting them of a new ride. I think that's a really interesting theory of liability. I haven't looked into that. I don't know, Rosa, if you have yet, but I think it's a great argument. And what I'd want to look through, and I would do discovery upon this in this situation, is first of all, you would want to have testimony from the passengers saying this guy was looking at his phone or laptop the whole time, clicking on things. I saw it said Uber on it, and I think they were looking for other rides and they were distracted at the time, and that's when the accident happened. That could be a basis. What, if any, steps has Uber done to make sure that the drivers that use its app can conduct business without having to look at a phone or an app while in transit? Do they have strict policies on that? What is it? I think that's a great theory. What do you think about that, Rosa?
I did see something when I was doing research, and I think, if I'm not mistaken, the Bongiorno case that I cite, which is that one from Richmond County from May of this year, I think that the judge talks about that.
Okay.
So that certainly is something, again, absolutely right. It must be distracting. They're constantly touching their screens when you're driving and they're driving you. So, I think it's a great argument. If I recall correctly, if it's that case, they kind of didn't give it much credence, but that doesn't mean you can't build up that argument.
If you're listening via podcast, the second attendance verification code for today's course is POD 637. Again, that's POD 637.
Okay. Nicholas is saying if a driver's policy excludes driving for hire, would uninsured motorist claim be applicable? If so, when must such claim be made? You want to field that one, Rosa?
I'm sorry, which was the question that you read, Andrew?
Yep. Nicholas, if a driver's policy excludes driving for hire, which we know that personal ones always do, would uninsured motorist claim be available or applicable? And when must you make such a claim?
Yeah. I mean, I think you can 100% pursue the uninsured, underinsured coverage is available. And are you talking about available through the car itself or through their own personal policy?
I think through the car itself, they're
Yeah.
saying. I don't think it would, right? If the policy says we don't cover you if you're driving somebody for hire, wouldn't that affect not only the liability but the uninsured? It would be the whole
Well,
policy.
you know what? There are cases that say that it does turn into an uninsured motorist case, because I remember litigating that and having a case like that. So there are cases out there that say you can pursue the uninsured, because I remember thinking that's really odd, right? And then I also remember seeing cases that said you can't. So I don't know if it's the case laws all over the place, but it's something to look into, because I definitely remember cases saying that when they disclaim on that it turns into an uninsured motorist case, which is kind of odd, right? There's still coverage under the policy.
Yeah. That's why you have to, policies are going to be different. There's no global policy or global rule that we can tell you, oh yeah, Uber never has uninsured, or in this situation, uninsured would apply or wouldn't. We get these questions pretty much on a daily basis to our office from people, and the first thing we say is send us the policy. Let's take a look. We have to look at the policy itself because different carriers write policies and language differently and implement it differently. Okay.
I see somebody's asking about where you get the materials. Michelle was in the link, right, when they got their
Yeah, there's a bunch of links in the chat for the material, so you can find it there. Shayna's asking, is there a difference of the drivers operating a vehicle for UTOG, UTOG? Do the same issues apply as Lyft and Uber? I do not know what UTOG is. Do you, Rosa?
No, I don't
Okay.
either.
If you want to let us know what that is. But again, it would be if it's a ride share app, the ride share is what we're pretty much talking about here. And whether it's Lyft or Uber, if UTOG is a ride share app, it would probably be the same principles. Fred is talking about that so much of recovery of a claim is based on available insurance. Well, that's our world of personal injury litigation, right? There's three things: liability, causation, and coverage. Damages, I guess, but four things. Sometimes there's no coverage, as we all know. Premiums can be affected, they may not be affected, but I don't see that there's some huge problem with people not being able to afford auto insurance, or these big companies or TLC drivers not being able to get the coverage that's the mandated minimum. I've never seen issues or concerns raised about that.
So Beth wrote, UTOG is a black car company. There is, when you look at the vehicle and traffic law, if you look at that section, where they talk about the network drivers, they specifically exclude certain cars. And I think it's like taxis, it might be black cars. So you have to take a look at the statute and take a look, because there's certain cars that aren't subject to it. I also see somebody else wrote in here that on Long Island, I'm sorry, Uber has UM outside the 5 boroughs. Okay, so that confirms my my experience. The case I had seen, there was UM coverage, but it was not a city case. So thank you for that, Chrissy.
Yep. All right, what else? We're cooking with oil.
Let's see.
All right, so this one, Rosa, I know you and I spoke about this. There's a question that what about companies like DoorDash, Instacart, Uber Eats, these food delivery services?
Yeah, so interestingly enough, the VTL does not discuss those services. So when you talk about transportation network company, it says the transportation of passengers. So it doesn't involve food, but I do know, and I might have cited in the materials, that there are 2 bills out that they're trying to pass to make insurance mandatory for those like Uber Eats and all that, because it's really just whatever that individual carries. Now, I'm going to tell you there's a distinction in the law with delivery exclusion, because there are cases, it's the famous pizza delivery case where the kid goes and he's delivering pizza from the pizza shop to somebody's house, and he gets into the accident, and then the carrier tried to disclaim coverage, saying he was transporting goods. And the court said, no, if it's indiscriminately that you're doing, pizza delivery here, you're doing a delivery of food here, there, they're not going to deem that excluded under the personal auto. So they should be covered under their personal auto policy for that kind of work.
Kyle has a question regarding SUM. He has a case where his client was in a Lyft that was T-boned by third-party defendant who ran a light. The third-party defendant tendered the minimum policy. The host driver's insurance also 25. Can I make an SUM claim against Lyft? You can if Lyft provides uninsured motorist coverage for that vehicle. And again, so you'll have to get the policy. That would be a case that we've been talking about where the fact pattern would be such that you would want to pursue an SUM because there's not enough coverage. So you look at the host vehicle, they only have 25. You're going to look and see if Lyft provides coverage, which would be great if they do. Then you go after that. If they don't, then you're going to look and see if the client and or his or her household has any SUM coverage. So you're going to want to explore all those. Again, you got to get the policies.
Here's a question. Does an insurer have an obligation to turn over its policy when a claimant requests it prior to filing an action?
Huh.
So no. The answer is no. They do have to disclose the limits. So there's an insurance law provision that says that once you make a claim, you can request the limits. And the reason for that, that's based upon SUM coverage, because you need to know whether or not you have a claim for SUM coverage. So you need to know the limits of the car that you're suing. So you can ask for the limits, but you're not going to get the policy.
All right, Joseph asked sort of the straightforward question that I want to take, because this is really what, as a plaintiff's lawyer, you're going to be faced with. The question is as follows. Quote, do you pursue the driver policy prior to pursuing Uber on the negligence theory if the case is in New York City and Uber argues no coverage for the driver? So here's the practical tip. Hopefully you'll know before you file suit that it was somehow an Uber app involved. Make sure to name Uber as well as the primary driver and registered owner. Litigate the case as one case. They're all in it together. You push it, you get the discovery, you request discovery from the driver, you request the discovery we've been talking about from Uber or Lyft. You do the depositions of everybody. You work it all up as if they're all in the case, right? Knowing that emotion may be coming down the pike. After discovery is done, or when you feel you're at a point where a case can be resolved, maybe the primary driver and registered owner is ready to tender their policy and the damages are greater than it, whatever it is, you're getting close to maybe thinking about settlement. You call up the lawyer for Uber or Lyft and say, look, I think we're getting close to resolving something with the driver. You know, what's Uber's position on this? Can we do a global resolution of the case? They'll probably respond and say, Uber's got nothing, but if you give me a reasonable number, maybe we can do something, right? And then you go from there. And then you set up maybe a mediation, and that's where it's going to depend on the factual record you've developed from discovery. So it's not really one or the other. You should do it all together. As a practical matter, our experiences, companies like Uber and Lyft aren't going to pay a dime until you exhaust the driver's insurance. So that's where we sort of deem them as excess. Whether they really are or aren't, remains a mystery. But generally speaking, you're going to have to get everything from the driver and registered owner first before they're going to agree to kick it in. Or, we had a case once where we knew the damages were well in excess of the $100,000 primary policy. And so we were trying to hit up the Uber/Lyft company to see if we could, get more. And they were like, well, we need to have confirmation that the primary will put it up. If they put up something, we'll put up something. And you sort of go from there. So that's the way you got to work these cases. You got to jump in to the deep end and work it all together as one case.
So I see something, Jeff Bloomfield said that there's a case, Emily Wu versus Uber Technology, that is scheduled for oral argument at the Court of Appeals on October 15th, 2020.
Oh, wow.
So thank you for that. That's good.
Yeah. Well, Jeffrey, if you monitor it, we'll try and monitor it as well. If anybody does see it or finds a decision, and we'll speak with Michelle. Can you let Michelle know? Or Michelle, if we have the ability through the academy to track that case, and then we'll let the members of the academy, which you all are, right? Everybody on this webinar is a member. If not, you need to be, if you want to get that email. We will email you the decision for the Court of Appeals, and we know it's going to be a good one for sure.
And there are several people in here who are just saying there's the cases all over the place in favor of Uber. So someone said in Queens, there's cases. So there's obviously that Duncan case, there's Richmond County. So it seems like it's going in that direction. From what everybody's saying here and from what I've seen as well.
Anthony's asking if the Lyft driver can make an underinsured claim. Again, if there's coverage for it. So if the Lyft driver's in a Lyft car with a passenger, they get hit, T-boned, rear-ended, they get injured, there's a minimum policy behind. That would be that trigger factor in a normal situation where that driver would want to pursue either underinsured, possibly workers' comp. So again, you'd want to explore that. I don't know. You'd have to see the policy, the Lyft policy, to see if they provide underinsurance. They may not. They may say it's not our problem. If the driver has an issue, they can pursue it with comp or elsewhere. So again, they certainly can try and pursue it. We're seeing a lot about them moving to compel arbitration. And again, I think that it's probably going to be binding, and whether they would split it. So I think in a question I'm seeing from Thomas, you have the two parties who are injured sitting in the back of the vehicle for hire. One ordered it on the app, one didn't. So we know the one who ordered it on the app is most likely going to be compelled to arbitration, which is going to stick. The question is then what happens with the other person? As a practical matter, if you're representing both passengers, I would figure out and try and pull them both in and maybe just do them both in the arbitration. Technically, you could probably file separate claims. That's going to be a decision that you will make, and you may want to speak with defense counsel and ask what their position is going to be if you split it up or if you do it together. So you'll have to play that one as it goes.
Just to read somebody posted, Stephen posted, even if a driver does not meet all of the rideshare internal requirements before being permitted to use the app, wouldn't such an argument be precluded under the doctrine that an entity's internal regulations, if broader than those required under statute, I guess, or common law, may not be used as a basis to prove or argue liability? I mean, certainly they're going to argue that. I think it depends on what the particular regulation or rule is, I mean, I know they run criminal checks and everything on these people. So, I think that it just depends on what the basis is. And certainly they're going to argue that. I agree, that it's not binding.
We have a question about Zipcar. Do you know if they have SUM coverage usually?
I don't know.
Yeah. I would imagine when you get a Zipcar and through their app, they're going to have an agreement of terms. All of these are, and we all click on them and don't read them, but they are binding. And so what I would do is if you are looking into getting a Zipcar, then I would take a look on their website, see if they provide it, if they address that at all, see if it's in the detailed terms. I would recommend to all of you who do not own a car, but use Zipcars a lot, rent cars, you can still get underinsured motorist protection. You don't need to have a car. A lot of people don't know that. You can purchase SUM coverage if you don't own a car. Just reach out to your insurance broker or, do your homework and look it up, or reach out to Rosa or I and we'll help you find somebody. But we had a client, a middle-aged woman who lived in New York. She never got her driver's license, lived in New York City her entire life. And sure enough, she was crossing the street, got hit by a car that had a 25 policy. She had a very bad injury. And she said, I think I may have some coverage for this. We said, what are you talking about? You don't have a car, do you? She said, no, but I purchased something. And she sent us a policy that she purchased that covered it. And lo and behold, she had a really good, I think she had a $500,000 SUM policy. And we filed for SUM arbitration and got it for her, got a good part of it. So if you're taking Zipcars a lot, I would get your own coverage, and it shouldn't cost you that much.
And the thing is, I find that on these websites, when you go onto the Lyft and you go onto the Uber, they have all of this information. It's public. And in fact, like I said, we have attached to the materials the certificates of insurance for Uber. They just put them out there like, this is what we cover, and they put it out there. So it's there. I have Robert Gruber is talking about SUM coverage, and he says, please explain for your audience that before underinsured is applicable, the BI limits between plaintiff and defendant cars must be compared, and plaintiffs must be greater. And if the sum SUM applies, the underlying recovery is credited. So in other words, what he's saying is, in order to even trigger underinsured coverage, you have to compare the liability limits to the liability limits. That's what you compare to determine whether you have a trigger of SUM coverage. So your liability limits have to be bigger than the defendant's liability limits. And then once you recover SUM, what he's also saying is that if, let's just say you got something from the defendant, you got $25,000, that is going to be offset from whatever you recover on your SUM. So what he's suggesting, which I agree with, is that buying a $25,000 SUM policy is a waste of money, because I mean, it basically is not enough for anything. I mean, maybe an uninsured, if there's no insurance, okay, you'll get 25. But that's really, definitely a waste. Thank you, Robert.
So I know because Michelle popped up that we're going to be wrapping up. I know we didn't get to all your questions. There's a lot of really good questions. Obviously, this is a subject matter that is ripe for more discussion. So reach out to us. Rose and I will be around. Email us. We're happy to help. Schedule one-on-ones with us. We can chat about these issues. We will have an SUM program. I think it's the one in January where we will talk a lot about SUM. There are questions there about when it kicks in, how it kicks in, how it works. We'll talk in great detail about that. And thank you all for chiming in, sharing your thoughts, asking good questions. This is what it's all about, right, Rosa? Right, Michelle? It's
Yeah,
the
exactly.
community that we have here. It's awesome. And we're going to keep it going. We will see you all on November 6th to talk about, this is going to be great. This is in construction accident litigation. Lots of insurance issues because you're talking about multiple parties there, owners, GC, subs, all that. So we're gonna spell that all out. So come ready for it next month. And thanks for joining us. We'll see you then.